Hi, I'm attorney Andrew Thompson. In this video, we're talking about representing individuals charged with a crime in a criminal case. Criminal defense and the presumption of innocence. The presumption of innocence is a standard in the United States courts of law made as a benefit to anyone charged with a crime. And it's a benefit that extends historically back to merry old England in the 16th or 17th century, the time of a great writer of the law named Blackstone. At that time, a series of rights began to develop, which were eventually adopted under our United States Constitution. The guarantee that if you are charged with a crime, you will not be found guilty of that crime unless you are found to be so beyond a reasonable doubt. The best protection for you in terms of maintaining this reasonable doubt standard is to have the facts of your case tried before a jury of your peers. There's a variety of reasons for that, and we'll go into them in a moment. But the protection of your rights is the essence of criminal defense, that you hire an attorney to do for you whenever you are charged with a crime and facing some type of penalty, including the possibility of jail or prison. Okay, the third protection guaranteed to you under the United States Constitution is that of the privilege against self-incrimination, or actually a right against self-incrimination protected by the Fifth Amendment to the United States Constitution under our Bill of Rights. This is why we have Miranda warnings. This is why you do not have to testify at trial on your own behalf. And sometimes, just because of the character or ability of a person to testify, their background, their emotional makeup, it might be wise for them to choose not to testify, even if they're truly innocent of any of the charges. Now, as an attorney, I'm faced with a question that you yourself may have asked before, quite frequently, and that is, how do you represent someone you know who is guilty? To me, this is an odd question, and it's odd for several reasons. Number one is it takes away the entire presumption of innocence right off the stage. The presumption is that the person charged with the crime is innocent until proven guilty, and not the other way around. In fact, regardless of what the charges are or how they were derived, what is known about the situation. And so our job as attorneys is to protect the individual who is charged with the crime. And this protection comes on a number of levels. It's not just the various protections that exist, but it's the levels at which we can protect the individual. So if it turns out that it's in the best interest of the defendant because the facts are stacked so strongly against him or her to plead guilty to a charge, one of the very important things that would come into play at that point in time is to take into consideration all of these rights that you're giving up and so much more. For example, one of the things that people often fail to consider carefully when they plead guilty to a crime is the rights that they're giving up, the fact that they will then be on probation, and that in order to revoke probation and go back to the original sentence that would have gone into place if the person had otherwise been found guilty and not accepted probation as an alternative, they may end up in jail without having an opportunity for a trial by jury, without having an opportunity for the protections they had before they pled guilty. This is why I go back to the notion that the best protection for the reasonable doubt standard is a jury of your peers. It becomes the attorney's job in a case where there is some gray area to demonstrate to the jury that there is reasonable doubt by which their client should not, in fact, cannot be found guilty. And this is the charge of the attorney when he or she goes to trial. That's what we do. We're fighters for our client. We take cases not to put guilty criminals back out on the streets, but to preserve that presumption of innocence to defend the rights of people who have those rights in a proper and appropriate way. It doesn't matter whether it's an alcohol-related charge, a drug charge, a felony of any kind. It can be even white-collar crime from fraud, embezzlement, conversion, theft, etc. It doesn't matter what kind of crime it is. Your rights are the same, and they deserve to be preserved and defended. We come to fight on your behalf. If you need help with any criminal defense matter, any charge that you face, please contact the Thompson Law Office today. You can call us at 317-564-4976 or find us on the web at www.thompsonlaw-in.com.